me say a few things about the Turkel Commission. After the Israeli interdiction of the self-declared humanitarian flotilla from Turkey to Gaza, there was, of course, a great deal of consternation about how this whole thing had been handled. And there were calls around the world, not only from the Turks, about the importance of an international inquiry. The Israeli government chose not to commit itself to that path, but instead to conduct its own commission of inquiry internally. But a choice was made, a decision was taken to appoint 2 international observers to be able to testify that the process was truly independent. And for phase 1 of the Turkel Commission, which was the inquiry into the incident itself and the role of the IDF in stopping the vessels and in boarding them, and in particular in the case of the Mavi Marmara, the exchange of lethal military force. The 2 international observers were Lord David Trimble, the former First Minister of Northern Ireland, former Nobel Prize winner for his involvement in negotiating a conclusion to the conflict in Northern Ireland, and now a member of the House of Lords. And the second international observer was a subject matter expert in the laws of war, former Canadian Judge Advocate General Brigadier Ken Watkin. These 2 joined the other members of the Commission, chaired by the retired Justice of the Israeli Supreme Court, Yaakov Turkel, hence the name. And the inquiry was undertaken over the ensuing months. Established in June 2010, the incident was 31st of May 2010. The Commission gathered together, I think, in July, and handed down their report in March of 2011. When the government first established the Commission, it always intended that the Commission would move on to a second phase, going beyond the specifics of the May 31, 2010 incident, and to consider Israel's mechanisms and processes for investigating alleged violations of the laws of war. So after the end of the tabling of the first report, the Commission moved into phase 2 and held its sessions of testimony from various representatives of Israeli government agencies, including the Attorney General himself, the Military Advocate General, a number of others, as well as some NGOs, and a whole weeks of testimony were heard. Ken Watkin had to return to the US. He's Canadian by nationality, but had retired from the Canadian Armed Forces and had to go to take up an academic position at the US Naval War College as a visiting professor, and he had to be gone by June 2011. So it was that point in the process that the members of the Commission tried to find a replacement for Brigadier Watkin, and they wanted subject matter expertise to replace what they had lost. Not an easy thing to do, because Brigadier Watkin's held in very high regard. I had a phone call about that and a conversation, and then a face-to-face interview, I guess you'd call it, in Sydney in May, in early June 2011. And on the basis of that process, I was formally asked to join the Commission, which I did, and to travel to Israel, the first of 5 successive trips over 18 months in late June 2011. That for me was a wonderful experience. At the time, then and still now, I act as a special advisor on international humanitarian law to the prosecutor of the International Criminal Court in The Hague. So it wasn't long after the Palestinian National Authority had lodged its declaration purporting to accept the jurisdiction of the court that this approach to me from Jerusalem happened. I said in the conversations I had that I needed to check with the prosecutor his view about my involvement in Jerusalem. Having accepted the position to be special advisor, I needed to check it out with him. So I had a chat to him, and his view was, which I'm grateful for because I certainly agreed with it, his view was that any country in the world, state party or not, to the Rome Statute for the International Criminal Court, that wants to take seriously reviewing its own national processes for investigating alleged war crimes has to be encouraged to do that. The court has to support that. If you want to do this work, you go and do it with my blessing, and if the Palestinians have any problems with that, I'll deal with it. I don't believe they did, actually. Certainly heard of no such thing. So with his blessing, I took on the position. And in the course of our work, the testimony had already been heard, but the task was then to write up our report. I think that took a lot longer than Justice Turkel hoped it would, and it's an extremely substantial piece of work. I've schlepped from Jerusalem, possibly the only hard copy of this report, all 950 pages of it, to Australia, and I wouldn't say I've never let that on my side, but held it closely. This report is structured along the following lines. First of all, we've undertaken a major study of the international legal obligations on all states, on all countries, when there are allegations of violations of this body of law, to investigate those allegations. What does international law have to say about what sort of investigation, who has to do it, how soon after the incident should it happen, what does independence and impartiality really mean? And then on the basis of our review of the international legal obligations, we've done a comparative study of 6 other countries and how they undertake their own military justice systems: the US, Canada, the UK, Australia, Germany and the Netherlands. And we've had an expert in each of those 6 jurisdictions writing a country report for us, responding to a list of specified questions about what actually happens in your domestic system. I wrote the report for Australia, and it was a very good experience actually for me. I didn't know much about the way investigations occur in the Australian Defence Force, and so I found that a very helpful exercise. So we took those 6 national reports and tried to synthesise them to identify where are the commonalities, where are the divergences, and our second chapter deals with that synthesis. Then we look in chapter 3 at the Israeli system for investigating alleged war crimes, and in chapter 4 how Israel compares to the other 6 countries that we've reviewed, and then our recommendations come. I should say that a lot of this 950-page material includes the annexes of each of the 6 country reports, so that makes it look a lot bulkier than it is in terms of the substance of the report itself. There are 18 recommendations, and I don't believe that any punches were pulled. For example, probably the most hard-hitting of any of the recommendations relate to the Shabak, or the Israeli Secret Intelligence Service, and allegations against it of mistreatment of those being interrogated. The Commission was presented with information that over a particular period, and I can't remember the number of years, there were 600 allegations, formal allegations of mistreatment, and not one of those resulted in any disciplinary action. Lord Trimble was horrified by that statistic. I think it's fair to say that actually all of us were, but Lord Trimble especially. And he insisted that 2 of our recommendations respond directly to that information. The first of them is that all the interrogations should be videotaped, not for YouTube posting, not for public audience, but to provide a record of what actually goes on. And that allegations of any mistreatment should not be investigated by the Shin Bet itself, but by the police, the Israeli Police Investigative Services, to create some independence in the process. Lord Trimble's view was that in Northern Ireland, it was when videotaping was mandatory for UK forces that allegations of abuse and mistreatment of Northern Ireland detainees under interrogation fell dramatically. There are a number of other recommendations that have to do with structural and procedural issues in the Israeli system, but I think it's also fair to say that our view in the Commission was that the processes that Israel has in place measure up very well against those of the other countries that we considered. In terms of the significance of the report, I'd like to make a few observations about that. I think, first of all, that the study that we've undertaken about the international legal obligations in relation to investigations is groundbreaking. In my 20 years of studying the law of war, I realised when I came to this material that I'd always made a leap between the substantive law and possible violations of it and the need for accountability and disciplinary proceedings. But in between those two steps, there is a very significant body of law and jurisprudence about the investigative process and the gathering of evidential material and whether or not the prosecutors responsible for initiating action have sufficient evidence to be able to launch proceedings. This study, in my view, is the most comprehensive and substantial study in English that's ever been undertaken on this subject, and I really hope that others take it seriously. I do know that in the context of the UN Human Rights Commission in Geneva, this part of the Turkel Commission report is being taken very seriously indeed. I also think that the Turkel Commission report is very significant for Israel itself. Israel chose to undertake this process and to set up an independent commission. I have testified in my International Observer's letter accompanying the report that in my view the process was thoroughly independent, as we would expect it to be. There was no evidence of any government intention to try to push the commissioners to make particular recommendations. We were free to decide what we thought we ought to do. I think the whole concept of Israel appointing international observers is one that should be applauded, and I really hope not only they but other countries also learn a lesson from that and try to take that sort of approach. In a commission of inquiry of this kind, where it's important that people are able to say objectively and from their perspective, this has been an independent process.